Welcome. This is the first of 9 YouTube videos based on the 2022 edition of A Detective's Guide to Interrogation Law. The 9 videos in this series cover all of the substantive content of that book, including answers to these real-world interrogation problems. Compelling suspects to unlock computer and cell phone passcodes. How to use Garrity and Kalkine's warnings while questioning public employees. Admissibility of admissions made by prisoners, probationers, or parolees as part of treatment or rehabilitation programs. The admissibility of a defendant's silence when accused of a crime. Things an officer can say and do to avoid a finding of Miranda custody. Questioning prison and jail inmates without Miranda warnings. The application of the Miranda rule to questioning at airports or borders. Obtaining Miranda waivers from uncooperative suspects. How to lawfully question suspects who have invoked their Miranda rights. What officers should do when defendants change their mind about invoking Miranda rights. Questioning suspects who have been formally charged or who have attorneys. How to manage jailhouse informants. How to work with prosecutors on investigations without creating ethical problems for them. Tactics for addressing insanity and diminished intent issues. Your obligation to advise foreign nationals of their consular notification rights. Working with police officers in foreign countries. This is all free. If you watch all 9 videos and internalize the concepts explained in those videos, you will have expert knowledge of interrogation law without spending anything but your time. Let me introduce myself. My name is Ed Hagan. I spent the first part of my career as a state prosecutor in Oregon, where I was also an adjunct professor of law at the University of Oregon. In 1995, I went to work for the United States Department of Justice, where I supervised the publication of in-house practical skills manuals for federal prosecutors. I also edited the DOJ's United States Attorney's Manual. I retired in 2018. Since retiring, I've run a website, trialdex.com, and have continued to write on legal subjects. I am the author or co-author of 4 books: The Prosecution Function, The Law of Confessions, 360 Federal Crimes, and the book covered by these videos, A Detective's Guide to Interrogation Law. A Detective's Guide to Interrogation Law is available for purchase from Amazon in hard copy and e-book versions, and it has helpful content that does not appear in these videos. Specifically, in the book, each legal point is accompanied by 1 or more case examples, short real-world illustrations of the legal point that are exceedingly helpful in understanding that legal point. Some of this material is intellectually challenging. You may find that the case examples help explain some of the more difficult concepts. Also, every chapter of the book is accompanied by source notes with citations to the cases that support every legal point. There may be moments in watching these videos where you will ask yourself, is that really true? Can I really do that? What do I tell the prosecutors if they question the technique? If you buy the book, you will have case authority that can be checked and shared with prosecutors. Finally, the book is well organized with a comprehensive index. It is much easier to go back and zero in on a particular issue in the book than it is to find the same discussion in one of 9 videos. But, as I indicated in my opening comments, all of the substantive content is covered in the videos. If you watch all 9 videos, you are going to learn a lot about interrogation law. I think that investigators who are serious about developing their interrogation skills will still be motivated to buy a copy of the book and or to urge their departments to buy it. It is good value and easy to find on Amazon. And if you buy a copy, be sure to post an honest review of the book after you've given it a read. But in any event, it is enough of a reward to me to be able to pass this information along to a wider audience. If officers are able to use these techniques to make cases and take criminals off the streets, I'm a happy guy, whether or not I make a buck off the book. One other thing to think about. In January 2022, the United States Supreme Court granted review in a California case, Vega versus Tico, to decide whether police can be sued in federal court for failing to give suspects Miranda warnings. If the court rules for the plaintiff, we can expect a significant uptick in similar lawsuits against police officers. You will also see these suits being brought against municipalities, arguing that the municipalities should be liable for failure to provide enough training on these issues. There has never been a time when training police on interrogation law has been more important. One quick clarification before we get started. Technically speaking, a confession is a statement by the defendant that admits all of the elements of the crime, while an admission is a statement by the defendant that admits a fact favorable to the prosecution. The rules for admissibility of a confession or an admission are the same, and the terms are used interchangeably in these videos. Confessions and admissions are obviously compelling evidence that the jury wants to hear, so why do courts throw them out? Confessions may be excluded because of a violation of a rule of evidence, a statute, the suspect's constitutional rights, or more rarely, as an exercise of a court supervisory power or to punish prosecutors for improper or unethical behavior. The first chapter of the Detective's Guide is an overview of these provisions. It does not have the specific real-life rules that will be explained in the other chapters. It is the sort of survey that first-year law students get in evidence and constitutional law courses, with a focus on the principles directly relevant to interrogations. So let's get started. Evidence rules have their origins in English common law, but are codified as rules or statutes today. Many states modeled their evidence rules on the federal rules of evidence and used the same or a similar numbering system. So our discussion today uses those rule numbers. Attorneys often use the term hearsay to describe a certain type of inadmissible evidence. Hearsay is defined as an out-of-court statement offered to prove the truth of the matter asserted. Confessions and admissions would certainly appear to meet that definition, but they are nevertheless declared to be not hearsay, that is, an exclusion from hearsay, by Federal Evidence Rule 801D2A and parallel state evidence provisions. A criminal defendant's statement offered by the prosecution under Rule 801D2A does not need to be incriminating or against the defendant's interest to be admitted. Anything the defendant has said is admitted as evidence so long as it is offered by the prosecution, the witness has firsthand knowledge of the statement, for example, where the witness is the interrogator or someone else directly hearing the statement from the defendant, and it is relevant. Relevance is determined by the court applying something called the Rule 403 balancing test that excludes evidence where the probative value of the statement is substantially outweighed by a danger of unfair prejudice or is otherwise misleading or a waste of time. The Rule 403 balancing test is often cited in support of a defense objection to the use of a defendant's silence. We'll look at that in some detail in the third video of this series. Another example of an evidentiary objection is a claim of privilege. There are a number of these, including attorney-client, marital, psychotherapist-patient, and self-incrimination. We will thoroughly cover self-incrimination in videos 3 and 4. The other privileges are outside the scope of this presentation. So, in summary, confessions and admissions are admitted if they are unprivileged, meet the requirements of Rule D2A, That is, they're offered by the prosecution and satisfy the first-hand knowledge requirement, and pass the Rule 403 balancing test. Some otherwise lawful interrogation practices are barred by statute. There are, for example, federal and state statutes that regulate the use of pretrial service interviews and functions, and the use of jailhouse informants. Most commonly, statutes in your jurisdiction may have special rules for juveniles, for example, requiring the presence of a parent for the interview. The Detective's Guide does not comprehensively survey state statutes. Officers are assumed to know their criminal procedure codes. Much more commonly, objections to confessions are grounded on the United States Constitution and/or parallel provisions of state constitutions. In these videos, we'll sometimes talk about violations of the Fourth, Fifth, and Sixth Amendments without strictly noting the application of the incorporation doctrine. Those amendments are not directly applicable to states, but are incorporated by the Due Process Clause of the 14th Amendment. So when, for example, we talk about a Sixth Amendment right to counsel in a state case, it is technically more accurate to describe it as the Sixth Amendment right to counsel as incorporated by the 14th Amendment. This distinction is explained more fully in the book and may have significance for lawyers in trial and appellate proceedings. But from an interrogating officer's point of view, the distinction is meaningless. The federal right and the state version of the right incorporated by the 14th Amendment are identical. So we'll generally use the shorthand reference of the federal right in these videos. To complicate this a tiny bit, both the 5th and 14th Amendment have due process clauses. So when we talk about due process in federal cases, it properly references the 5th Amendment due process. And in state cases, it is referenced as 14th Amendment due process. No incorporation is required in those circumstances. Once again, the due process rights are identical under each amendment, so there are no real-world distinctions as far as an interrogator is concerned. So we'll usually omit references to incorporation when talking about constitutional rights in general. So with that understanding, the constitutional objections we will cover here are voluntariness claims, which are grounded in the due process clauses of the 5th for federal cases and 14th Amendments for state cases. We will look at those in the next video. Due process also prevents the use of silence after a defendant has been advised of the right to remain silent. This is the Doyle rule, and we will talk about it in the third video of this series. Claims that the defendant's right against self-incrimination was violated are grounded on the self-incrimination clause of the Fifth Amendment. The Miranda rule is derived from the Fifth Amendment, but there are a number of non-Miranda Fifth Amendment issues as well. We'll break up our discussion of self-incrimination and talk about non-Miranda self-incrimination issues in video 3 and the Miranda rule in video 4. We often talk about a Miranda right to counsel, but there is a separate and distinct right to counsel protected by the Sixth Amendment. It is very important to distinguish between these two rights of counsel. The Sixth Amendment right to counsel will be covered in video 5. A confession that comes after the officer has illegally detained the defendant or where the defendant has been confronted with illegally seized evidence will result in defense arguments that the defendant's Fourth Amendment rights have been violated. This is sometimes referred to as fruit of the poisonous tree and is covered in video 8. In cases where there are no pertinent statutes, rules, or constitutional provisions that bar admissibility, courts will sometimes get to a desired result by ruling that the court has inherent or supervisory power to do so. The most well-known example is the McNabb-Mallory rule, applied in federal cases where the confession is made after the defendant has been denied a speedy arraignment. We will cover that in video 7. As you know, prosecutors have special obligations regarding the attorney-client relationship that are grounded in attorney rules of ethics. Accordingly, there are circumstances where contacts with suspects are lawful for law enforcement officers, but problematic for prosecutors. This sensitive area is covered in Video 6. While most confessions rules are based in some way on the United States Constitution, one must recognize that state courts are free to fashion more restrictive rules governing the admissibility of confessions in state courts based on state statutes and constitutions. Bear in mind, though, that while state courts may create stricter rules, they can't make federal rules go away. A state court can, for example, apply the Miranda rule where a federal court would not, but it cannot fail to apply the Miranda rule where it is required by federal law. So, federal law is a baseline that state law enforcement officers must observe, and so they must have expert knowledge of federal confessions law. Also, many states, notably California, declined to extend the exclusionary rule to state constitutional violations. In those states, federal and state rules are essentially the same. So, you made it to the end. Thanks for that. This is the first video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. If you have comments about the presentation or questions about some of the points I've tried to make in the video, I can be reached by email at contact@trialdex.com. The next video covers voluntariness, that is, confessions obtained by physical or mental coercion, deceit, or promises of immunity. The key concepts covered will be the state action requirement and the totality of the circumstances test. I hope to see you there.